Okay, this is being recorded and it will be housed most likely at the Senior Citizens Legal Services website and potentially the Self-Help Center website for later use. My name is Tanya Rodino and I am the Executive Director at Citizens Legal Services. And I'm really pleased to be sharing this information with you today. This webinar is brought by both my organization and the Santa Cruz Superior Court. Our offices are in a partnership program right now. It's the second time in history that we've been able to do a partnership such as this. And this partnership is focused on providing housing information to both landlords and tenants throughout Santa Cruz County. I think there's no question, but there's quite a housing crisis throughout the state and nation. So we've been pleased to try to help people understand these complicated legal rights. And this focus today is on the unlawful detainer process from the landlord's perspective, certainly to the extent that landlords better understand all their legal obligations, more tenants can be safely and legally housed. So again, today's presentation, we focus on the landlord's perspective. We will be offering this recording in 2 more weeks on the 28th, I believe is the date, and that will be the unlawful detainer process from a tenant's perspective. So please feel free to join us for that last webinar as well. All right, again, my name is Tanya Rodino. I am also joined today by Buffy Almendarez. She is the current SCLS Senior Legal Court Partnership Assistant, been helping at the Law Library serving individuals, and she's going to be helping me today with the slides. So thank you, Buffy, for all you are doing. I wanted to make sure that you first knew that everybody's welcome to receive further information about housing rights. If you can flip the slide once, Buffy. The next slide has information about how to contact the Self-Help Center and the Law Library. So the Law Library is located at 701 Ocean Street, and they are amazing there and always available with information. Again, right now we have SCLS senior legal staff there on Tuesdays and Thursdays to help with more information. You can also reach them by phone and by email, and they are responsive to all questions by both phone and email. You're also welcome to join to ask any questions at SCLS as well. Senior Legal has been around for 50 years. For those who don't know, we have been providing free legal services to seniors since 1972, and we help in a wide variety of areas, but currently the housing market has been the largest majority of the cases that we are seeing. So we see quite a lot of people handling their housing needs. So let's go on to this webinar, and if you can flip the slide one more time. This is just a timeline of how a landlord will go through the process of evicting somebody from their home. So it is a very complicated procedure, and this is a quick kind of, again, a timeline. First off, you do have to be what's called the notice stage, and this is providing an appropriate written termination of tenancy notice. We'll go into more detail about the different types of notices that are required, but you have to start by giving a written notice to your tenant. Only after that notice has been given and that time has terminated can you then go on to the second stage, which says here the filing an unlawful detainer. So this is when you actually file your papers in court and you begin the unlawful detainer process, better known as an eviction process. And after you file those papers in the courthouse, they have to be served on the tenant. So that is just the second stage. After serving the tenant, you will wait 5 days. All individuals served with such papers have 5 days to provide their response. So as a landlord, you'll wait 5 days after serving the tenant, and you'll call the court to find out if they had filed an answer or not. If they did file an answer, this is when you will request a trial. And if they didn't file an answer, you can simply file what's called the default judgment. So again, we'll get into more details about all of this, but we're also going to talk today about after that hearing or after a judgment is granted, you'll then get into the fourth step, which is the writ of possession. you'll get this judgment essentially from the court, and that is the document that you will bring to the sheriff's office. So again, after your judgment, you get a writ of possession, and only then does the tenant finally actually get evicted by the sheriff. The sheriff will take this writ of possession and execute it. It says here that they should do that within 5 days. My understanding is that Santa Cruz County has been quite backed up, and that it has been taking up to 2 weeks to actually to execute the writ of possession. All right, well, let's go into more detail about each of those sections. On the next slide, please. So this can be very complicated, and we definitely suggest that you talk to a lawyer or you talk to somebody at the law library who is well versed in these proceedings, because unfortunately, if you get your notice wrong, you're pretty much not going to be able to proceed down the line somewhere. At court, most likely the judge will discover that the notice was not correct, and you will then have to start all over by getting a proper notice. So very important that you understand what the situation is and what notice you can use. Often landlords are hoping to use a 3-day notice, but again, this is only for certain types of situations. Most commonly, most sadly nowadays, a lot of 3-day pay or quit notices based on failure to pay rent. So if an individual has not paid rent, you are then able to use this. It is 3 court days. Very important that you understand that it's not holidays or weekends, but 3 court days. Also important to understand that if you've used this notice, you have to accept rent during that 3-day notice period. So if the full amount of rent is offered during that 3 days, you are required to accept it, and you can no longer proceed on a 3-day notice. Other 3-day notices are based essentially on breaches of the lease. If it is a curable situation, which would be such as not extreme nuisance or an extreme waste or subletting or something very illegal occurring on the property, then it would become a curable situation, and that would be a 3-day cure or quit notice. So the 3-day cure or quit notice, again, that's used for violation of a rental agreement that can be remedied. And again, it's court days, not holidays or weekends. Once again, if the tenant does cure during this 3-day notice period, then this notice is no longer valid. More commonly, we see a plain 3-day quit notice, and this is on a very serious, egregious situation that you do not believe can be cured. It's important to note also, we're going to talk a lot about what's called the TPA, the Tenant Protection Act. And so we will go into a lot of details about that. It has complicated things quite a bit, but essentially important to know that if the TPA does apply to this particular type of premises, then after giving your 3-day cure or quit notice, you're actually then required to give your 3-day notice. So if it's not cured within that initial 3 days, then you give the 3-day to quit notice. And that is only if the TPA is required. So that's a little bit about the 3 days. Again, I know this is a bit complicated, but you're welcome to ask for further help at any time. We can help you figure out which notice is required. A little bit more easy to understand, I think, are either the 30-day or the 60-day notices. Those are essentially based on the amount of time that the tenant has been in the home. So any person that has resided for less than a year can be given a 30-day notice, and that does not need to state cause, because the TPA does not yet apply if they've been there for less than a year. So under a year, you can give a 30-day notice. As soon as a tenant has resided for more than a year, they are required to be given a 60-day notice for termination of the property. If the premises is under the TPA, then that 60-day notice would also need to state cause. If it is an exempt property that is not covered by the TPA and the tenant has been there for over a year, then that 60-day notice would not need to state cause. So that's the gist of which notice you can initially use when you are ready to request a tenant be leaving a premises. We will go on to the next section. Important to note that there is one other type of notice that is required, and this is for all Section 8 tenancies. If an individual is receiving a government benefit for housing, or the landlord of the premises are otherwise contracted with the government, then they are required to a 90-day notice. So that is a special situation. They're required to a 90-day notice. It's been quite controversial to determine whether or not these particular types of tenancies with a Section 8 housing voucher are covered by the Tenant Protection Act or not. The Attorney General and many agencies across the state have taken the position that Section 8 tenancies are not exempt from the TPA, and thus all the TPA requirements also need to be provided to a Section 8 tenancy. Okay, we can go on to after the notice is given on the next slide. So we're going to get deep into the TPA right now. Again, on the next slide, we'll talk a little bit about whether or not the TPA even applies, because there are a lot of exemptions that would bring the property out of the TPA protections. But before we get to that, we'll just start about what the TPA is. So essentially, these additional protections for tenants were just cause requirements. So they were an act that provided a landlord provide a reason for evicting an individual. And so this is the just cause. This is the cause for the eviction. And it's going to be basically split into no fault causes and at fault causes. So if the tenant is at fault for one of these various reasons, you can read them there. Again, the non-payment of rent, material breach of lease, the nuisance of property, waste on the property, refusal to execute a written lease renewal or extension. That can be a little bit tricky because the extension or renewal has to be basically at the same as the current lease. But if they refuse to renew it, then that could be an at-fault cause. Criminal activity on the property, unlawful subletting, certain refusals to allow a landlord access to the property after having given appropriate notice. And other various reasons would be considered at fault. So if there is an at fault reason, then you do not have to pay the relocation assistance, which is required by a no fault eviction. Again, you just need to keep in mind that if some of these are curable, that they have to be given a 3-day notice to quit an opportunity to cure. On the no fault lease terminations, these are pretty big. So there are a lot of reasons that you can get out of a lease just by saying that the family, your family, immediate family is moving into the property, or that you are otherwise withdrawing the property from the rental market. So if you're taking it off the rental market, or if you're having family move in, those are the big primary reasons that we see the no fault cause. Also an intent to demolish the property or substantially remodel. I think it's interesting that the intent to demolish is in the same sentence as substantially remodel. I mean, it's not supposed to be we're just upgrading the bathroom. It has to be a substantial remodel in order to qualify for that no fault just cause. And then the fourth reason is owner compliance with a local ordinance or government agency or court order. So if otherwise you're being made to take this property off the market or cease a lease, then that would also be a no fault cause. And again, if no fault is listed as the reason, the landlord is then required to offer relocation assistance to the tenant. This is it is equal to 1 month's rent. A lot of landlords choose to waive the last month's rent in order to qualify for that in order to meet that requirement. Okay, this is another big slide. This is the exemptions from the Tenant Protection Act. It has been said that the exemptions might in fact swallow the Tenant Protection Act. There are quite a lot of exemptions. These are all the reasons that the TPA would not apply to the rental situation. So again, I already mentioned the primary one. This is for any tenant that has been on the premises for less than 1 year. And it's not just the one, but all tenants have to have lived on the property for less than 12 months. If any tenant is been on the property for less than 12 months, I'll just read it, or no one over 24 months if any tenant has been there for less than 12 months. So that gets a little bit confusing when there's more than one tenant on the lease. Again, any questions, make sure you bring this either to an attorney or our offices or the law library for help to make sure you're getting this right. Other exemptions, I'll just go through them quickly. Tourist hotels are not required to follow this. Nonprofit hospitals, extended care facilities, residential facilities, licensed care facilities, those are all not protected by the TPA. Student dormitories are not protected. Owners, where the owner is the principal residence in the home and they're leasing out other rooms, if they share a bathroom or a kitchen facility with the tenant, then the TPA does not apply. This is a very common one that we see here with our housing market the way it is, with landlords needing to rent out rooms in their home. They are not required to follow the TPA. Another common situation is a single family owner occupied residence, where the owner rents or leases no more than 2 units or bedrooms. Again, be sure to ask if you need any help interpreting any of this, but I'll say it again. A single family owner occupied residence where the owner rents or leases no more than 2 units or bedrooms. This is very common when there's an ADU on the property, for example. So as long as there's not a lot of ADUs, that will also be exempt from the TPA. Another situation is 2 units in a single structure in which the owner has occupied one of the units as a principal place of residency since the beginning of the tenancy. This is very common in duplexes. So as long as one landlord lived in one side before he began renting to the tenant, then that would not be subject to the TPA. Also, new housing is very frequently excluded. So any housing built within the last 15 years is not protected. Essentially, they're not wanting to prevent new development from coming up, or from stopping landlords or stopping developers from creating new homes. So they wanted to make sure that protection was in there. Certain housing restricted, that's to provide affordable housing. So some affordable housing is not protected, but again, it has been determined that Section 8 housing vouchers should be receiving the TPA protections. But again, that's a bit controversial of a situation. Certain property alienable separate from the title. If there's not, what is this? I can't read this whole thing. There we go. My picture was in the way of the slide. So property alienable separate from the title to any other dwelling unit that is not owned by a real estate investment or an LLC. And in that situation, they have to have gotten written notice to the tenant initially that they are exempt from the TPA. So that is important also. And finally, like I said, there is this section in the written law which says property subject to local rent control or just cause ordinances that might provide greater TPA protections. So that's not typically applicable here in Santa Cruz, but there are certain areas in the Bay Area, for example, or Berkeley, that has quite strong rent control. And if it is greater than the TPA protection, obviously the TPA wouldn't then apply. So that is the long list of exemptions. Certainly the first thing that any landlord wants to know is, are they subject to the TPA? And so this is where you would go to find that out. You want to carefully read all the exemptions and determine whether or not you are subject to the TPA as a landlord. Okay. So if you have decided that you are moving forward and you have provided the appropriate notice to your tenant, only after that notice period it has indeed gone through, then you can move forward with the filing of an unlawful detainer. So this is the actual paperwork that is filed at the courthouse. And again, this is a list here of required forms. It might not look like that much here, but it can be quite complicated. So we do hope that you can get some assistance filling it out, or carefully review all the paperwork. There is a summons, there's a civil cover sheet, there is a relatively new plaintiff's cover sheet and supplemental allegations. That one, the UD 101, like I said, it's relatively new. It has to do a lot with the TPAs, making sure that you followed all the various details of the TPA. So that's an important new form. The UD 100 is the long time standard complaint form that a landlord has to fill out and file. And then finally, very importantly, the POS, the proof of service. This document is essential that it's filled out correctly, and it provides the courthouse with the information about how you served both the notice. Well, this particular one is how you served the unlawful detainer forms. Your proof of service of the notice will also be included inside the UD 100 complaint form. So all of these forms need to be together, filed at the courthouse. The filing fee needs to be filed at the courthouse. And after the clerk gives you back those documents, you can have them served by someone 18 or older and not a party to the case. Super important. Hopefully you know this. You cannot serve your own legal documents. And after they're served, the tenant then has 5 court days to file a responsive pleading. If they've been personally served, if they're served by posting or otherwise, that time is extended. Okay, next slide, please. This is a very common situation in our housing crisis. We sometimes have occupants that might not be named on the lease. And it's very important that if you think there are any other occupants that are in the home, you really should be cautious and go ahead and check the box on your complaint form that says that there might be what's called does. Jane Doe might be living in the home. You might not know her name. So if there are other occupants, you want to check the does box on the complaint form, and you're also going to use an additional form called the pre-judgment claim of right to possession. So this is an additional form, that's the CP 105, and you are going to fill that out and have a process server or a sheriff serve that form on the unknown occupants and or have it posted and mailed. It's very important that you have proof that you served this document to the unknown occupants. If not, at the time you may think that you are done, you could then be given this form by one of those unknown occupants, and then you will have to go through that whole process with them. So again, you don't want to wait till the end, think you've evicted your tenant, and then find out that there's unknown occupants involved. So if you think there might be other people in the home, or you know there's other people in the home, but you don't know their name, make sure you go ahead and use this prejudgment claim of right to possession. Okay, next slide. Service can be hard. You definitely are supposed to be trying to personally serve these documents on the tenant so that they are aware of the situation. Super important that this is not done by surprise. If after much due diligence, you are unable to personally serve each individual tenant, you are allowed to do what's called substituted service. So substituted service is most generally when the documents are given to another adult in the residence, or someone who seems to be in charge at the tenant's workplace, if you can prove that it's the tenant's workplace and you can prove who it was given to at the workplace. So this is substituted service. You're giving it to somebody else, an adult at the property or someone at the tenant's work. After giving the documents personally to this other adult, you will then mail the same documents to your tenant's last known address. That is considered substituted service and is valid for starting your cause of action in court. If you've done substituted service, the tenant has 10 days after the forms were mailed, as opposed to the 5 court days when they're personally served. And that's 10 days on top of the 5 court days to respond. And finally, if you are unable to do either personal service or substituted service, you can also request that the court allow you to post and mail these documents. You'll have to fill out additional forms requesting that at the court, and after getting court permission, the court will post and mail this document to the tenants, and they will then again have the 10 days and the 5 days to file a response. Hopefully that can solve most service dilemmas. So after waiting the appropriate either 5 or 15 days from service, the landlord will be responsible for figuring out what the next step is. The next step is either going to be requesting that the case be set for trial if the tenant did file an answer, and if the landlord determines that the tenant did not file an answer within the necessary time, within that 5 or 15 days, then you will request a default judgment. So I'll back up just a bit. If the landlord, again, after the time either the 5 or 15 days has passed, if the landlord determines that the tenant did file a response, then the landlord will request the case be set for trial by filing what's called the UD 150. It's just another form that you have to fill out and file. Once filed, the trial will usually be set within about 2 or 3 weeks, about 20 days from the date that the request is filed. And that will be the date that you have your hearing to prove your case to the judge. Again, if the tenant fails to provide an answer, they do not get their answer filed within those time periods, the landlord can instead request a default judgment. It is a series of forms that are required in order to do that. Again, you can get help at the law library if necessary, but you're going to be filing your request for entry of default, the CIV 100. You're also going to actually fill out the judgment that you want the judge to sign. They don't want to do any of the work over there. So go ahead and fill out the judgment as you would like the judge to sign it. And that's the UD 110. And then with that, you'll also file a writ of possession. That's a form that you're going to get and then give to the sheriff. That's the EJ 130. You may also need to request a dismissal of does if you listed does in your complaint and they did not join or provide any pre-service judgment right to you. After the default judgment is granted or after your court trial, when you finally have your writ of possession, that is when you will bring to the sheriff. So the default is itself a 2-step process. First, you regain possession by the court. You can give that writ of possession to the sheriff. After your possession is restored, if you still want to seek money judgment or any undue paid rent, for example, if you did request that in your initial complaint, you will then do that in a separate case, essentially, in either civil or small claims. So again, in the default judgment paperwork itself, you are not able to get any money judgment. That is for possession only. And if you want your money judgment, you have to then go back to court in either civil or small claims. Okay, next slide. Wrapping up the unlawful detainer. If you've made it this far, you might finally have possession. Again, either at the default judgment or after your hearing. If you do have a hearing date, you will show up at the hearing and be ready with all of your paperwork and all of your proof, and be ready to convince the judge that you did indeed give those notices and you did indeed serve that unlawful detainer paperwork properly, and that you did or didn't have just cause. So either at that hearing or at the unlawful or the default judgment, after you get your writ of possession, that is what you are going to bring to the sheriff's office. Again, my understanding that the sheriff has had about a 2-week turnaround for actually posting their notices and following through with the writs. But in any event, once you get that writ of possession, bring it to the sheriff's office. They will, as soon as they can, post a notice on the tenant's door, notifying them that they now have 5 days in order to be fully off the property, or they will be locked out by the sheriff. If the tenant leaves the property after vacating the unit, you must provide the tenant with a notice of their right to reclaim any property. This is a real frequent problem where landlords are unfortunately left with a lot of the stuff that the tenant may have left behind, and I understand you just want to throw it away. Unfortunately, you could become responsible if you were to throw it away without providing proper notice. So the best thing to do if there is property is to store it in a secure location for 15 days and provide notice at the last known address that you have this property. You can charge the tenant fees for that storage, but I know unfortunately it can be hard to go through the process of collecting those fees, but it is your right to at least try to request them. But in any event, that is your responsibility of left behind belongings to give the individual notice, and then only after that notice period is expired can you finally be able to throw it away without being concerned that you will be in trouble for doing so. So that is important. Also very important, after the unlawful detainer is wrapped up, on the next slide, we'll talk a little bit about the security deposit. Very important detail. If we can move on to the next slide, please. Thank you. Again, nowadays, with money being very tight for so many people, the security deposit is very often at issue. And landlords need to understand their duties. They do have a duty to return the full deposit to a tenant before 21 days is up. So you've got 3 weeks to figure out what you're doing with security deposit, no more. Tenants can get their full deposit back if it's not returned on time. And they can also try to get treble damages if they can show that you failed to return that security deposit in bad faith. So you do want to be very careful about this. You are able to deduct from the security deposit damages to the property and undue unpaid rent, but you cannot include normal wear and tear. A lot of information out there about what normal wear and tear is, so make sure you get familiar with that. Most particularly carpets and walls, those are going to get dirty when a tenant is there and you're not allowed to charge them for that. But any actual damages or things that are wrong definitely can be deducted from the security deposit, but you have to write it down in an itemized list of deductions with receipts if you already have the receipts. If the work has not yet been performed and you don't have actual receipts, make sure you still go ahead and do that itemized list of proposed deductions within the 21 days, and then you can follow up with actual receipts when the work is complete. But definitely within that 21 days, you want to have an itemized list of what you are planning to deduct, if anything, and or return the entire security deposit, so the tenant might be able to find a house somewhere else. If damages go over the amount of security deposit, I hope this doesn't happen to you, but if it does, you are allowed to seek that money. You would need to do so in a small claims action. So we would suggest that you send a letter carefully detailing what the charges are. And if they are refusing to pay them, you would need to file a small claim suit. And if the damages are under $10,000, if it's over $10,000, unfortunately, you would need to do that in a civil court case, which is a much more work than just a small claims. So that is the financial aspect of the case. And I think that wraps up the slides. Again, we've started from the beginning, the landlord deciding that they would like to ask a tenant to leave. They have to start by giving the appropriate notice. Make sure you have that notice correct. Only after that notice period is done can you then file in court. So we talked about the procedure in court to file for your unlawful detainer. And again, if you have any questions about whether your property is subject to the Tenant Protection Act or not, make sure you seek legal help. There is several attorneys in town that specialize in landlord tenant law, and the Santa Cruz Law Library has been providing services for landlords for a long time, and Senior Citizens Legal Services also helps in some situations, most particularly with landlords who are renting in their own homes to other tenants. So thank you very much. I will see if there have been any questions posted during this webinar. And if not, or even if there are, again, you can always seek help at the courthouse. Buffy, are there any questions right now that came through the chat?
At the moment, there are no questions.
Thank you. That means I was super clear and it all makes sense. Okay, well, thank you all for joining me today. And thank you again, Buffy and the courthouse, for the partnership. It's a real honor to provide the services that we provide at Senior Legal, and I wish you all the very best. Okay.